Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. Hey, just dropping in to say we're now on Patreon. If you want to support the project, head on over to patreon.com/legallistening, where you can unlock some fun bonus content with me, Zach, and some special guests. Thanks so much for all your support. So today on the podcast, we have a very special guest. Antonio Giamberadino is our guest reader today. He is a lawyer in the West End of Ottawa, and he's going to read the Divisional Court decision of Milne Estate, which is a fairly recent decision. I believe it's from last year. So we're very excited to have him. And Zach, why is this an exciting decision?
So this is an exciting decision because this is part of a block of first recordings for us. This is our first estates case that we're featuring on the podcast. So we're super, super thankful, and we have to give full credit. I believe he's a sole practitioner, so the fact that he's willing to dedicate some time to this is amazing. Yeah. Incredible. Incredible.
So we're very excited. We certainly don't know anything about estates, so we are very appreciative for those who are reaching out and reading these decisions for us. And with that, Antonio, take it away.
Hi there. My name is Antonio Giamberadino. I'm a sole practitioner in the West End of Ottawa, Ontario, and part of my practice deals with wills and estates. And so today I'm going to be reading the Divisional Court decision of Milne Estate. This was one that was on everybody's radar. Even LawPro sent practicing lawyers an email regarding this because of how it touches on primary and secondary estates. For those of you who don't practice estate law, one of the, basic tools of estate planning that we have in Ontario is the idea of using primary and secondary wills. Namely, to get around the estate administration tax, you provide a will with public assets that need to be probated, and those are submitted to the court and taxes paid on them. And then for privately held assets, things that you don't need probate for, chiefly privately held family-run business or the like, those can be dealt with in a private asset will. However, what's been a typical drafting convention has been for wills and estates lawyers to put a clause in there saying, hey, trustee, you can decide whether or not an asset is public or private and move it in between the two wills accordingly. And that was at issue before the original motions judge, and or rather the application judge. And he held that it did not meet the three certainties of a trust and therefore was not a valid will. And this went to appeal to the Divisional Court. Ontario Superior Court of Justice, Divisional Court, heard by Morocco, Swinton, and Sachs, in the matter of the estate of Sheila Marilyn Milne, deceased, Lorianne Milne, Sylvia Webb, and Brett D. Murray in their capacities as estate trustee of the estate of Sheila Marilyn Milne, in the matter of the estate of John Douglas Milne, deceased, Lorianne Milne, Sylvia Webb, and Brett D. Murray in their capacities as estate trustees of the estate of John Douglas Milne, appellants, and the Toronto Lawyers Association as intervener. Heard at Toronto, December 11th, 2018. Nature of proceeding. John Douglas Milne and Sheila Marilyn Milne died on the same day. Each died testate, having executed mirror primary and secondary wills. Each primary will was submitted to the Ontario Superior Court along with applications for a certificate of appointment of estate trustee with a will limited to the assets in the will, certificate of appointment. After calling for and considering submissions by the estate trustees, the application judge in Milne Estate Re 2018 held that both applications should be denied on the following basis. A will is a trust. The three certainties required for a valid express trust are applicable to the wills, such that the allocation clause found in the primary wills results in uncertainty of subject matter because each clause fails to identify the deceased's property to which it applies. And 3, the inquisitorial jurisdiction of the court in matters of probate allows for a declaration of invalidity to be made in such circumstances. The appellants are the executors of each primary and secondary will. The appellants request that the application judge's order be set aside and that the estate's registrar in Ontario issue certificates of appointment of estate trustee with a will limited to the assets referred to in the primary will in favor of the appellants. The Toronto Lawyers Association was granted intervener status in these appeals. It supports the position of the appellants. Background. John and Sheila Milne both passed away on October 2nd, 2017. They each left mirror primary wills and secondary wills, dated May 10, 2016. The wills named the appellants Lorianne Milne, their daughter, Sylvia Webb, their accountant, and Brett D. Murray, their solicitor, as executors. On October 17, 2017, the appellants filed applications for certificate of estate trustee with a will limited to the assets referred to in the will for each of the deceased's primary wills. These applications were accompanied by an affidavit of Mr. Murray, certifying that the primary will had not been revoked by the secondary will. The primary wills read, "This is the primary will of me. With respect to the disposition of all property owned by me at the time of my death, except, subparagraph F, any other assets for which my trustees determine a grant of authority by a court of competent jurisdiction is not required for the transfer or realization thereof, as to which I am making my secondary will on the same day as this primary will. With the exception of the said secondary will, I revoke all previous wills." The secondary will read, "This is the secondary will of me, with respect to the disposition of all property owned by me at the time of my death, including, subparagraph F, any other assets for which my trustees determine a grant of authority by a court of competent jurisdiction is not required for the transfer or realization thereof. As to the remaining assets of my estate, I am making my primary will on the same date as the secondary will. With the exception of the said primary will, I revoke all previous wills." The appellants' applications came before the application judge on January 24, 2018, who required written submissions to support the applications, as he was, quote, "not satisfied that the primary will can be proved absent the secondary will, for so long as the estate trustees can determine in their discretion what assets are excluded from the primary will," end quote. After receiving written submissions, the application judge determined that an oral hearing was required, which occurred on June 15, 2018. The oral hearing and the proceedings took place without opposition. Decision of the application judge. In his reasons, dated September 11, 2018, the application judge decided that, quote, "The central issue raised by this case is whether the will is a valid will if there is uncertainty as to the subject matter of the trust created by it," end quote. A will is a form of trust, which in order to be valid must satisfy the formal requirements of the Succession Law Reform Act. A valid trust, and therefore a will, must demonstrate, quote, "certainty of intent to create the trust, certainty as to the subject matter or property committed to the trust, and certainty as to the objects of the trust or the purposes," i.e., the three certainties. The application judge found that the only certainty at issue was the secondary certainty regarding subject matter. The application judge also held that it was proper for him to examine these elements at the probate stage, because the probate function of the court has an inquisitorial function that demands that it, quote, "ascertain and pronounce what documents constitute the testator's last will and testament," end quote. The application judge concluded that where the will on its face gives rise to questions of validity, the court is required to inquire into its validity. The application judge found that the language of the primary Milne wills raised issues about the certainty of the subject matter, which went to their essential validity. The application judge held that the subject matter must be definitive and ascertainable at the time of death, when the will creates a trust. The primary wills conferred discretion to the executors to later decide which assets would be subject to the primary will of each testator. The application judge held that the primary wills were not valid and could not be accepted for probate because they excluded a set of assets at Clause F, which could not be objectively ascertained. The application judge remarked that the secondary wills were valid because they applied to all the property of each testator. However, the appellants had only submitted the primary wills for probate. Key issues. The appellants submit the following issues. 1. Did the application judge err in holding that a will is a trust? 2. Did the application judge err in holding that the, quote, 3 certainties determine the validity of a will? And 3, did the application judge exceed the court's inquisitorial jurisdiction? Divisional Court's jurisdiction. This court has jurisdiction to hear this proceeding pursuant to Section 10, Sub 1 of the Estates Act, which provides for appeals. Standard of review. The appropriate standard of review is correctness, because the issues on appeal are questions of law arising from an order of a judge. Primary and secondary wills are a commonly used technique. The validity of the use of multiple wills, i.e. primary and secondary wills, was confirmed by Justice Greer in Granovsky Estate v. Ontario, 1998. The use of primary and secondary wills is often used to reduce tax payable pursuant to the Estate Administration Act, to avoid the delay associated with obtaining a certificate of appointment, or preserve privacy in respect of certain assets. Because a testator often executes their last will and testament several years in advance of death, it is not often practical to provide a definitive list of assets which will require or do not require a certificate of appointment to be transferred or realized at the time the primary and secondary wills are executed. To overcome this practical problem, estate planning lawyers often provide estate trustees with the power to determine whether a particular asset requires a certificate of appointment upon administering the will. These clauses are often referred to as allocation clauses. The use of allocation clauses is a common estate planning technique. See Martin Rochwerg, Miller-Thompson on Estate Planning, 2018, at paragraphs 2 to 57. The position taken by the application judge in the order, therefore, has a significant and wide-ranging adverse impact upon the use of such clauses in multiple wills, thereby affecting the estate plans of many individuals in Ontario. For this reason, the Toronto Lawyers Association sought and was granted intervenor status in these appeals. The power to allocate cannot be exercised arbitrarily. The fact that an allocation clause is discretionary does not mean that the power conferred by it can be exercised arbitrarily. The power of an executor to allocate must be exercised in accordance with the standards applicable to a fiduciary. See Donovan, W.M. Waters, Q.C., Waters' Law of Trusts in Canada, 4th edition, Toronto, 2012, at page 990. The decision in Panda Estate, Re. 2018. The Panda Estate decision arose as a result of a motion for directions. The motion raised the same issues as those in the present appeal, as only the primary will of the deceased had been submitted for probate. In response to the motion, Mr. Justice Penny granted the application for a certificate of appointment of estate trustee with a will limited to the assets referred to in the will. Mr. Justice Penny declined to follow the decision of the application judge in this case. Mr. Justice Penny decided to issue the certificate of appointment because he was not prepared to find that a will was a trust, and therefore he was not required to apply to 3 certainties. I agree with Mr. Justice Penny's reasons and conclusion in this regard. Although not necessary for his decision, Mr. Justice Penny also indicated at paragraph 31 of his reasons that he was not inclined to view that a direction from the testator about how the estate trustees should decide whether or not to seek probate in respect of 2 or more wills dealing with particular components of the deceased's property created an uncertainty sufficient to invalidate the will. However, it was His Honor's view that resolution of this question should occur in a case where the issue was raised, quote, in the context of a mature dispute, end quote. Mr. Justice Penny also decided that the role of the court on an application for certificate of appointment as estate trustee with a will is to determine whether the document presented is the testator's last will, which requires that the document is 1. In writing, 2. Signed at its end by the testator in the presence of 2 or more witnesses who subscribed the will in the presence of the testator, and 3. Testamentary, i.e., that it discloses an intention to dispose of the testator's property upon his or her death. It was Mr. Justice Penny's view that broader questions of interpretation and the validity of powers of appointment or other discretionary decision-making conferred on estate trustees are matters of construction, not necessary to the grant of probate. A will is not a trust. At paragraph 14 of the application judge's reasons, he states as follows. A will is a form of trust. In order to be valid, a will must create a valid trust and must satisfy the formal requirements of the Succession Law Reform Act, SLRA. There is no issue here regarding compliance with the formal requirements of the SLRA. The application judge cited no authority in support of the statement that a will is a trust. I agree with Mr. Justice Penny that this is an error of law. A will is an instrument by which a person disposes of property upon death. See Albert H. Oosterhoff et alia, Oosterhoff on Wills 8th edition, at page 107. There are, of course, formalities of execution, but they are not raised in this appeal. A will may contain a trust, but this is not a requirement for a valid will. The definition of a will in Section 1 sub 1 of the Succession Law Reform Act does not state that a will is a trust. Section 1 sub 1 provides that, quote, will includes A. a testament, B. a codicil, C. an appointment by will or by writing in the nature of a will in exercise of a power, and D. any other testamentary disposition. Further, the nature of a beneficiary under a will confirms that a will is not a trust. See C.H. Sharon et alia, Williams on Wills, 9th edition, at paragraph 1.8, quote, although the title to the assets vests in the personal representative, the property comprised in residue is not held in trust for the beneficiary under the will so as to invest any equitable interest in him. It is in fact a fallacy to seek separate existence of the equitable beneficial interest in the assets during the period of administration. End quote. In Commissioner of Stamp Duties, Queensland v. Livingston, 1964, Viscount Radcliffe makes the same observation. Quote, when the whole right of property is in a person, as it is in an executor, there is no need to distinguish between a legal and equitable interest in that property, any more than there is for the property of a full beneficial owner. What matters is that the court will control the executor in the use of his rights over assets that come to him in that capacity, but it will do it by the enforcement of remedies which do not involve the admission or recognition of equitable rights of property in those assets. End quote. Section 2 sub 1 of the Estates Administration Act vests all real and personal property of a person who has died in the deceased's personal representative, which is precisely the situation contemplated by Viscount Radcliffe. Specifically, Section 2 sub 1 provides as follows, quote, all real and personal property that is vested in a person without a right in any other person to take by survivorship on the person's death, whether testate or intestate, and despite any testamentary disposition, devolves to and becomes vested in his or her personal representative from time to time as trustee for the persons by law beneficially entitled thereto, and, subject to the payment of the person's debts so far as such property is not disposed of by deed, will, contract, or other effectual disposition, it shall be administered, dealt with, and distributed as if it were personal property not so disposed of. I appreciate that Section 2 sub 1 states that the deceased person's property is vested in the personal representative, quote, as trustee. Waters' Law of Trusts in Canada, 4th edition, provides a helpful explanation of why executors seem to have been conflated with trustees, which I accept. Quote, however, there is also an historical reason for the similarity of the rules applicable to trustees and personal representatives. The administration of deceased's estates was originally handled in England by the ecclesiastical courts. For a short time, the common law courts took over this task, and then in the 18th century, the Court of Chancery assumed control. The law of trusts was still in its early formative stage at this time, and therefore the law governing both trusts and the administration of deceased's estates developed together from that point in the same court. There were and there remain distinctions between the two, a good example of which exists in the personal right of the legatee to trace the deceased's assets into the hands of third parties, a right which the trust beneficiary may not have to the same extent. But by and large, through 19th and 20th century statutes have now drawn some further small distinctions, for example, as to the powers of personal representatives. Jessel M.R.'s words still remain true. In modern times, the courts have not distinguished between executors and trustees, but they have put them all together and considered that they are all liable under the same principles. End quote. It is with regard to the liabilities of the two that the offices so closely approximate today. End quote. In conclusion, the application judge erred in finding that the will was a trust. However, even if Section 2 sub 1 creates a trust in favor of those persons beneficially entitled to the deceased person's property by law, the trust is created by statute, not by will. Indeed, Section 2 sub 1 applies whether or not the deceased left a will. Finally, if Section 2 sub 1 creates a trust, that trust is statutory and not subject to the three certainties. If the three certainties apply, the subject matter of the primary wills is certain. If I am wrong and the will is a trust and the three certainties must be satisfied for the trust and the will to be valid, the subject matter of the primary wills is certain. As indicated in the circumstances of this appeal, the only issue was certainty of subject matter. Even if the three certainties apply, the subject matter of the primary will is certain, and therefore the subject matter of the trust created by it, assuming a trust is created by it, is certain. In the Law of Trusts, 3rd edition, at page 43, Justice Eileen Gillespie provides the following definition concerning certainty of subject matter. Quote, "The certainty of subject matter requirement has two components. First, a trust must have property that can be clearly identified as its subject matter. Second, the terms of the trust must define the portion each beneficiary is to receive or must vest the discretion to so decide in the trustees." End quote. Obviously, we are concerned with the first component. The property in the primary wills can be clearly identified because there is an objective basis to ascertain it, namely whether a grant of authority by a court of competent jurisdiction is required for transfer or realization of the property. As a result, the executors can allocate all the deceased person's property between the primary and secondary wills on an objective basis. The personal representatives are instructed to ascertain if a certificate of appointment is required in order to transfer or realize the asset, which can be done by consulting the institution concerned, and then categorize the asset in one of the wills according to that objective criterion. Finally, if the executors mistakenly allocate property due to a misunderstanding concerning the necessity of obtaining a certificate of appointment, their error is unrelated to the description of the property that is to be the subject matter of the trust. Accordingly, I am satisfied that the subject matter of the primary wills is certain. The scope of probate review. As indicated, it was Mr. Justice Penny's view that broader questions of interpretation and the validity of powers of appointment or other discretionary decision-making conferred on estate trustees are matters of construction and not necessary to the grant of probate. While I am inclined to agree with Mr. Justice Penny's view and reasoning in this regard, I am satisfied, therefore, that Mr. Justice Dunphy exceeded his jurisdiction. Such a conclusion is not necessary to decide this appeal. Conclusion. This appeal is allowed. An order will go allowing the appeal and setting aside the orders of the application judge. There will also be an order that the estate's registrar in Ontario issue in favor of the appellants the appropriate certificates of appointment. Neither the appellants nor the interveners seek costs, and accordingly there will be no order concerning costs.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.